receive complaints, I receive information about how police service, some personnel, pursue members of parliament from both sides of the house. And I've on a number of occasions intervened to talk to the authorities and to draw their attention to the law. Even sometimes I have to call the Attorney General and Minister for Justice in this matter. So apart from this, I myself had decided to come with a very comprehensive statement on this matter and let people know that members of parliament have some special rights because of the peculiar nature of the position, the functions, and the duties of the member of parliament. It's not during my tenure of office that I will sit still, stare, and allow those things to be flouted with impunity. It won't happen. And let it be known that the power of the people is stronger than the people in power.
Because the Public Order Act says that when there are problems with demonstrations, it is the leaders you hold for
the leaders will be held accountable.
Okay.
And I think our action emanates from that clause of the Public Order Law.
Okay.
Therefore, we've not shown any sign of impunity, and I believe that we have several options, as I indicated earlier on. We can go in, with a criminal summons, serve him, and if he fails, and in the wisdom of the court, it issues a warrant of arrest, then we implement it.
Your officers have been summoned before the Privileges Committee. Are you going there or you're calling their bluff?
Oh, one as a state institution, whatever it is, when that is done properly, and the police administration notified, the administration may take a decision on it.
This is the law. Welcome. It's your legal lights. It's your health law. I'm Samson Ladi Anyenini, and this afternoon, can't thank Kweku Paintsil enough. He's made time to join us once again. He's the head of Paintsil & Co. Thank you so very much, Senior.
Thank you very much.
And also joining us from the KNUST Faculty of Law is a lecturer, Mame Ifwa Adaji Co. Thank you so very much for making the time to join us.
Thank you.
Right. So to start with, the two of you have seen the footages that we have just shown. First, of the MP at the demonstration, and I think after the police were unable to effect the arrest, they sent him an invitation and he declined. So he announces at this in this footage that he has declined the invitation on the basis of the immunity that he has as an MP. Then we heard the Speaker of Parliament, and the Speaker of Parliament clearly gives us further particulars that this is not the only situation, but there are several others pending before him. So it does clearly appear that there are many other MPs or some other MPs that the police need to deal with either by some investigation or some other thing, but there is this conflict as to interpretation of Article 117. So then the last footage was ACP Kwesifori, Director Acting of Public Affairs of the Ghana Police Service, who told me on Newsfile yesterday that they have not been trying to do anything wrong. They've just been trying to keep to the law. And if it becomes this difficult, what they are likely to do is to simply issue summons, criminal summons, and then leave it to the court, potentially to issue bench warrant for the arrest of the persons that they need. So let me take your preliminary commentary from what you have seen and heard, starting with you, Kweku Paintsil.
Yeah, I think what I heard from the MP is right. I think he's relying on what he claims to be his parliamentary privilege to resist arrest, and I think he's wrong. He's a lawyer. The thing about police arrest is that you've got no right to look the police in the face and tell them because of some peculiar privileges or some peculiar rights, or even your denial of the allegation that constitutes the offense, that you will not submit to the arrest. The point of the matter is that that determination is to be made to a court of law. In other words, the police, upon suspicion that somebody is committing a crime or somebody is in the act of committing a crime itself, has got the power to arrest. And when they arrest, they're entitled to do so after they have informed you of the reason for effecting the arrest. And if you think you've got any reason, any good reason, any special reason, it is not for you to tell the police. It's after the police have gone through what they have to go through and process you for court. At that time, in any case, when the police get to know all the facts, they are not obliged to put you before a court of law merely because they've effected arrest, because they are entitled to make a judgment whether indeed they've got enough facts to put you before a court of law. So I've always maintained that the position where Ghanaians in particular will start by claiming that they did not commit the offense and whatever as a reason for not attending to the police is wrong, and it's definitely wrong for a lawyer to start an action on that note. That's my initial.
But
yes,
the process of arrest,
yes,
may be resisted if the arrest is unlawful. Republic versus Asante, is it not?
It's unlawful only if the police have failed to do what the law requires them to do, which is to tell you in a language that you understand the reason for effecting your arrest. That is the only circumstances. Because if you don't know, a policeman comes to confront you and you slap him, you beat him. I think Republic versus Asante, he told the policeman's uniform or something to that effect. And the court said that as long as the police had failed to tell him the reason for arresting him, he was entitled to behave in the manner that he behaved. But from what I see from the tape, the minister speaking for a point of knowledge. They had informed him that they were arresting him. Maybe, I do not know.
It's an MP, not a minister.
Yeah, so the point I'm making is that it's very possible also that they would have told him the reason that they were arresting him, which was in connection with the demonstration that he had led. And therefore, he has sufficient information. What I see is that he has started to more or less raise his defense to the action. That defense includes the privilege. Because if you come before a court of law and the police have charged you and it is your case that that particular activity that you were involved in is covered by parliamentary privilege, it is to the judge that you say that. If the police themselves are sufficiently convinced in the course of their investigation that this was truly the case, then they are not entitled then to prosecute or to proceed to prosecute.
Okay.
And the remedy, you see, I'm making that point because the law also provides the remedy of malicious prosecution.
Yeah.
Because
I asked that question and also deliberately because this platform is intended to give education.
Sure.
And on this same platform, we have given the education that there is a certain arrest which is unlawful,
sure,
which the law allows you to resist.
Sure.
Okay. All right. Mami, what do you say, Mami Efua?
On my part, I think that both sides have a case, and both sides also do not have a case, and it creates a sort of gray area that requires further clarification, either through the courts or through the law. And I'm saying this because on Mr. Sosu's side, that is the MP, like you were saying in Asante versus the Republic, it creates options of just being merely invited by the police, which you can decline, unlawful arrest, which you can resist, and then lawful arrest, which you cannot. And then on the side of the police, which is making the arrest, he had the defense of invoking his privilege as a member of parliament in attending to parliament or on his way to parliament, which also raises other issues that need to be thrashed out. And I believe through the course of the program, all of these issues to be settled. So that's my initial comment on it, that I don't think there's a black and white yet because of certain gray areas in the law that needs to be settled first.
Right. So let's begin right from Article 117, which is the issue now. That provision says that civil or criminal processes criminal process coming from any court or place out of coming from any court or place out, I'm trying to read from the television, I've stopped, let me read from my own. Coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member or the Clerk to Parliament while he is on his way to, attending at, or returning from any proceedings of Parliament. So, what will you say about that? The MP says, I was doing a demonstration as part of my parliamentary duties. The police say that cannot constitute parliamentary duties, and that the law covers attending to, attending at, returning from.
All right. So when you look at the clause, that's the Article 117. The issue with that clause, which I was talking about, the gray areas early on, is that what is the definition of on his way to? What is the time limit for on his way to? When does it start? When does it end? Is it an hour to parliamentary proceedings or parliamentary business? Is it a day? Is it 24 hours? Attending at would probably not be an issue. Returning from, how many hours or how many days after returning from Parliament are you returning from? Is it 30 minutes? Is it an hour? Is it 2 hours? So because the law, and there are no cases in Ghanaian law on this issue of defining on his way to, attending at, and returning from, we need clarity. And when you look at this provision is replicated in the Parliamentary Act of 1965, Act 300, Section 20. It repeats the same thing and it adds a few things, but still does not address the time limit between on his way to, attending at, or returning from. In Australia, for example, the law used to be that on his way to and returning from was 40 days before the parliamentary proceeding or the parliamentary issue, and then it was reduced to 5 days. So in Australia, for example, if you arrest an MP 5 days on his way to Parliament, 5 days on returning from Parliament, which will be business and working days, you cannot arrest or you cannot serve any process on him. But then we don't have that in Ghana, and I think that one of the ways to settle it is it's either to amend the Parliamentary Act, which already exists, to further provide those details and delineate very clearly what attending to, on your way to and returning from means in terms of the time, the place, the activity, or to choose the option of going to the courts. The little issue with going to the courts would be that in trying to interpret this provision, because it's a constitutional provision, the courts risk legislation from the bench. And so I would prefer that Parliament itself, since they are the lawmakers and already having an act in existence, can just amend the act to further provide for those details of what they mean by on his way to, attending at, and returning from.
Can you help us explain further what you mean by the need for clarity and that there is some gray area with the expression on his way to? Why do we need to explain on your way to? Why do we need to explain returning from? From what? From Parliament or from proceedings or a business of Parliament? Why do we need to explain that? Isn't that straightforward English? Plain? So that when you are asleep, you are not attending to Parliament. When you are in church, you are not attending to Parliament. When you are in the mosque, you are not attending to Parliament or returning. When you are in the markets, maybe you are going to Parliament, but you decide to go to the market to get some groceries. You are not on your way to Parliament.
All right. So first of all, I'll say two things. The first, let me answer the question you asked first before I say the other thing. So the first part is, for example, taking Mr. Sosu's case, Honorable Sosu's case, for example, he stated that he informed the police that after the protest, he was going to attend to a parliamentary business in Parliament. And so sort of, he would have been moving from one place to Parliament, and he made a detour through the protest gathering before he was going to go to Parliament. And so it may seem simple for everybody, but the law and the way lawyers act or handle or interpret the law is what creates the controversy. And so once there are two opposing or conflicting interpretations of what the law means, then it calls for interpretation. Because like I said initially, on my way to, is it that on my way to is 30 minutes? Because, for example, if an MP is coming from within Accra to Parliament, they will take a lesser time than somebody who is driving, let's say, from Kumasi to Parliament. Coming from Kumasi to Parliament, I may take maybe about 5-6 hours to get to my destination on time. An MP who is already in Accra may take about 2 hours. Are you going to say so? So because of that, on our way to has different timings. I'm using 5. The one from Kumasi is using 5 hours. The one from Accra is using 2 hours. And so, at what point in time do you say that we are on our way to? So we need to define it, because so that it doesn't create confusion about maybe somebody is going to Parliament, and then while they are going to Parliament, they decide to go for a checkup at the hospital before they go to Parliament. Will that be on their way to? So the clarity is needed so that there is absolutely no ambiguity.
All right.
It is unequivocal that this is what it means to stay on your way to.
I'd like you to briefly also look at this before I come to Kweku Paintsil, and then in the course, I'll be asking the question whether there can be any exceptions to the going to, attending arts, returning from, so that the question has been asked. If you are attending to Parliament, or even in the business of Parliament, in the heat of it, and you commit a certain crime in the face of the police, must they still require something before they can deal with you? The 1182 says the certificate of the Speaker that a member or the clerk is attending the proceedings of Parliament is conclusive evidence of the attendance at Parliament. When does this come to play? And does this not resolve the question you raise?
Once again, it's this provision is also problematic a little bit, and the reason I am saying that is because when you look at the original draft of the 1992 Constitution, that the Committee of Experts report, in drafting these provisions, Article 117, Article 118, and then the article on the service of an MP as a juror, it was together. And then what you just read in Article 118 came after it, saying that the certificate of the Speaker that a member or clerk is attending the proceedings of Parliament for all the reasons stated above is conclusive of attendance at Parliament. But now, Article 1182 has been tied to Article 1181. And so you could arguably say that the certificate of the Speaker is only required when it relates to the immunity from witness summons, and not when it is immunity from service of process or arrest. But then again, because of the case we have in Ejechum versus Akwete, where the court allowed for room for the scrivener's error, so that it would be that it was when the drafters were drafting it that they made a mistake. It would also take the court to let us know whether Article 1181 plus 2 applies only to Article 1181 or could be extended to apply to Article 117.
Brilliant. Thank you so very much. Just hold on for us, and let's have Kweku Paintsil also give us his take. How should we interpret 117? On your way to, attending at, or returning from any proceedings of Parliament?
You know, I believe, in relation even to the context in which this whole matter is being discussed, that we haven't a storm in the teacup. Because in all the situations that you've mentioned, it's a question of fact whether somebody was attending to or from or was actually in parliamentary proceedings. And that's why, for the avoidance of doubt, the Speaker under 1181 could settle that issue by a note under his writing. So in the context in which, for instance, that we find this particular issue, in which the MP has said that from that place he was attending parliamentary proceedings, it was a question of fact whether indeed he was. If he was going to attend parliamentary proceedings, then it was quite clear that the police had no right to effect his arrest at the point that they wanted to do it. Question is, how does the police determine? The rule is that there is somebody, there is an office to which they could verify the bona fide or the truth of the allegation that the MP was making at that point in time. So that whether 1181 is tied with 2 or not, somebody still has to certify. Somebody still has to confirm. The only other thing that I do not agree with or have my real doubts about is about the claim by the MP that his participation in the demonstration was part of his parliamentary duties. As for that one, I've got a lot of problems with that kind of assertion that he made, that engaging in a demonstration with your constituents is part of the duties of a parliamentarian. I wouldn't know which part of the Constitution that he derives that meaning or that explanation from. But as far as 117 is concerned, my point is, at every point in time, it's a question of fact. And therefore, whereas in my earlier remarks I've said that what the MP said was not sufficient for the police to possibly leave him, the idea was that if they took his word at that point in time, and they were not sure, or they did not believe, or they had reason to doubt, then they could still effect the arrest. Indeed, what happened in the video that we watched was gangsterism. I mean, it was much more dangerous than anything else. And I'm talking about civilians who raped an MP from him, and the money he also paid off, like we're watching a film. This is from the old Road West. I mean, the world we call the Wild Wild West. And therefore, in summing up my point on this matter, and why I said that it is a storm in a teacup, democracy has to be lived. The police do not have to behave as if they did not arrest him at that point in time, hell was going to break loose. Especially he's an MP. And therefore, they afford him certain courtesies, in fairness to him. Because even if you want to arrest me, and obviously, unless you have got reason to believe that at that point in time, I'm on my way, running out of the country or whatever, you have to accord me the courtesies to allow me to report to the nearest police station and so forth and so on. So my real worry is why, of all people, a parliamentarian, with due respect, they've got a double layer of protection. Apart from the normal protection given to you and I by the Constitution, they've got this 117 as a double layer. And therefore, in the circumstances, in my honest view, it was an unnecessary display of force by the police in insisting that whatever he said at that point, he must follow them. I mean, that's my clear view of this matter.
So they gave in at that point.
Yeah.
And then they invited him.
Yeah.
Then he declined the invitation. Then, as we were told yesterday, they wrote to the speaker on that same day, asking the speaker to release him for their investigations. And the speaker has written back to them that he's not going to release him. What do you say to that?
I mean, that's a joke, I mean, that's what we call corny in local parlance. It's a game that they're all playing with us. Because in one sense, the speaker wants the public to believe that the MPs do not have an absolute immunity. Now, the very protocols that the police ought to establish for purpose of dealing with honorable people is that you write to their head, who is the speaker? And therefore, if the speaker would, in one respect, say that you're not giving us those parliamentary privileges or you're not according us the necessary respect, there can be nothing more respectable than the police writing to the Speaker of Parliament requiring. Because, see, at the point that...
Why didn't they think about that first, but attempting to arrest him before that became an issue? Then they couldn't effect the arrest or stop trying to effect the arrest, and then he invited the gentleman, and then he refuses. He makes it public that he has declined because he has parliamentary immunity before they would now think about writing to the speaker.
Well, I mean, with due respect, it's only a fool doesn't change his mind. If the police started one process and somewhere along the line they had hiccups or they had problems, I think I will commend them at least appreciating that what they started with was wrong, or for any reason did not achieve the desired result. Then they will come back to protocol and do what otherwise they are required to do. But if the speaker also, at the point of the receipt of this letter, now behaves, if what you're saying is true, then I would say that the speaker is not being fair to the police. And this, it's a perfect standoff between the legislature and the executive, because don't forget that the police are under the executive. And I've got other comments as we go along. Yes.
This is a clear case of a clash between the lawmaker and the implementer. How does it get resolved? Now, I'm coming to the question now about whether or not there are any exceptions even to this rule, if so-called that is a rule. Professor H. Kwesi Prempeh says, the only office holder with constitutional immunity from criminal process or prosecution during his or her incumbency is the president. MPs only have qualified immunity that is designed to enable them attend to their work as MPs. The immunity, therefore, is tied to their work, not to their person or their position. Is this accurate?
It's perfect. It's a perfect definition. And indeed, I had the same thought, even though I hadn't read it, especially when the MP claimed that engaging demonstrators as part of his parliamentary duties. In other words, he's trying to give the impression that wherever we find him, then privilege is accorded. If a constituent of his is having a naming ceremony and then he goes there and if the police got evidence that he has done something wrong, then as long as at the constituent naming ceremony, then parliamentary privilege goes there.
No, I think that may be stretching it, because I've heard the MP and he says he doesn't think or believe that MPs have absolute privilege.
No, it's not what he says, but it is, you see, it's not just what he says, but I'm talking about his conduct. I'm interpreting his conduct, because a logical extension of that kind of privilege that claims that if an MP organized a demonstration, he participates in it, he called the activity that he has organized part of his parliamentary duties. But we know what parliamentarians are supposed to do is that by lawmaking, there are related or ancillary functions. But if we find ourselves at any point in time and we ask ourselves, what are parliamentary duties or functions? Would anybody on the top of his head believe or think that organizing a demonstration is part of parliamentary duties? So that's where we need a definition of what a parliamentary duty is, because that is what attracts that privilege. So that any time that we can agree that what the parliamentarian is doing at any particular point in time could be defined under the Constitution as a parliamentary duty.
You are saying,
yes,
that despite the clear expression in the Constitution that the MPs have immunity, if the police engages them,
yes,
that is not the point to waive the immunity in their face.
Yes.
But when they have engaged with the process,
that is so,
including before the court.
If the police decide to push it to the court,
why should I wait for you to trample upon my right before I say I have it? It's not trampling upon
your right, because your right that the law has given to you, subject to other rights that the police have also got. I mean, come on, please. I'm a lawyer, okay? If the police come into my office and say they believe or suspect me of being involved in, call it whatever, is it enough for me to tell them that, no, I've never even met the people you're talking about, I've never engaged in this crime before, and so forth and so on? Unless I submit myself to it, whatever defense that, indeed, the waiver of privilege is part of your defense. Somebody has to assess that defense. If the police choose not to believe you, let's even say that they are, with due respect, they're being foolish, okay? Or they have deliberately closed their eyes. That's why I've always reminded you about other rights that the law gives to people who are prosecuted maliciously. So, I mean, this thing happens in everyday life.
Mami Ifua, what do you say? Because people who have followed us on the law show here will be asking, but you lawyers say we should know our rights. What is the purpose of knowing our rights? We should know them so that when we are confronted with a situation, we can tell law enforcement that this is my right. You can't do this. I am an MP. I know I have immunity. And you come arresting me, and I'm telling you that you can't arrest me because I'm in the middle of my work. What's wrong with that?
So what is wrong with this scenario is that there's a misunderstanding and there's conflict between the two parties as to what the meaning and the effect of that provision is, and which Lawyer Paintsil was saying, what is the meaning of parliamentary business, parliamentary duty, which goes back to Article 117. So the whole conflict comes from different or conflicting understandings of that provision, and I think that's the basis of it, because if the police are aware of A, B, C, D constitutes parliamentary business, then immediately they attempted to arrest him or invite him to their end, and he raised that issue, they would hold back and go back to take the necessary steps before they try to call him back or arrest him. So I think that it's a misunderstanding of the law and what the law means. And so it's a call for clarity.
Yeah, so my question is, at that point, you have clearly stated the case of Asante versus the Republic, where he resisted the arrest because it was unlawful. And the court confirmed that he has a right to resist the arrest. At what point should Sosu have said what he said to the police? And at what point should he continue to say, you can't pick me up?
I think he said what he should have said. That was the best time to say what he said. That is when he was being invited. And I'm sure that if they hadn't whisked him away, the police would have taken him. And so it is in the moment. And remember, even for the Asante versus the Republic, this issue ended up in court. And that's how come we have the privilege of talking about it this way. So somebody was still violated, rights was violated anyway before the courts came to clear the air. So he did what he could in the moment, and that was all that he could actually do within that moment.
So let's now get to this and be straight to this. What should the police do now? They extended an invitation, and as we heard him in the video, he said, I have immunity. I will not attend to the invitation. I will not honor it. I decline it. So he said that to all of us. We heard it. Then they have informed us, confirmed to me on Newsfile yesterday, that they wrote to the speaker the same day, asking the speaker to release him, because that's the protocol they have developed. The speaker, according to them, has written back and says, I'm not releasing him. What should they do?
They should arrest him on a weekend.
They should arrest him on a weekend?
Yes. That's on the lighter side, but on what? First of all, because there's still the misunderstanding, the only thing is you cannot possibly be going to Parliament on a Sunday or attending to parliamentary business on a Sunday within the meaning of Article 117 as we understand it now until there's further clarity. So he would have to be arrested at a time where he could not possibly be engaging or reasonably foreseeably be engaging in parliamentary business, which could be on a weekend, on a holiday, if he's at a program that is not related to a social event that is on the side of the police. For
the MPs, they will be at a social event because of their position.
Right. So that
will be parliamentary duty. They are doing the work of a parliamentarian. Or that is different from proceedings of parliament.
Yes, but assuming that he's picking up food through a drive-through, he's on his way from church or on his way from the mosque, those other personal events, it's like trying to trace a person so that you can serve him a court process. It would be the same way in which they would have to trace him to be able to find him at a time where he could not possibly be on his way to or returning from or attending parliamentary business. But then aside the immediate, this immediate remedy to try to get him in their custody, the other thing they can do is to try and seek for an interpretation from the Supreme Court.
There are some who say they should do the first part that you suggested. Then those who disagree should rather go to court, not rather the other way, that the police go into court and to seek any clarity. But guess what? It's being reported in the media this moment that the police have been to the Honorable Francis Sosu Saviour's Church to attempt to arrest him. And the information we are getting is that the minority chief whip has gone to his rescue, and they would have left the church by now or so. Either the police or national security has been to the church to arrest him, and this may have happened. What should the police do?
I think it's a very unnecessary show of force. First place, I don't believe it lies in the mouth of the honorable MP to assert the privilege by himself by refusing or failing to attend to the police. That's the first point. Secondly, in spite of what he's done, I think in fairness that the police needs to go a notch up higher. In other words, I would rather they go to court and secure a warrant for his arrest, lay the bare facts before a judge, and if necessary, avail him or through the speaker a copy of the application on the basis of which the warrant is sought, and let the court decide this matter at this stage. This got nothing to do with interpretation at this point in time, because what is really happening, for me...
If you listen to the speaker, it's not just this case. There's a lot of it.
Yeah, but I'm happy...
And he says he's actually planning to do a thorough statement on this.
Yeah, you know what excites me about what's going on is that, in one sense, it shows me that the police are beginning to have teeth with which to bite. The police are beginning to assert themselves. The police are beginning to assure Ghanaians that irrespective of who you are, the rule of law will work, irrespective of whether you're in parliament. And I'm very happy that we're having this, because for a long time, it's the basic rights that we've been asking for people, the clients that we have, that nobody gives a hearing to. Now that it's gone up, we'll begin to see how it plays out. So that's one point. So therefore, we now see. But at the same time, I have major problems with the police myself in the way that they enforce the rights that they have. Because in our side of the world, it appears that everything has to be done by force. This business of informing people to report themselves and so forth, with due respect, I mean, come on, we are all equal before the law. But some people, by reason of their background, by reason of their stature, by reason of their state in life, by reason of their occupation, are not flight risk. So, for instance, in the particular situation we're talking about, we know it's a demonstration that they went. I mean, we know that even though we hear there were ties bent and stuff like that, there's no real casualty.
They simply are saying the road was blocked, which they shouldn't have done. Okay, they are showing us some of it.
Why?
And then there were burning of ties. These are against the law.
Yes.
And the Public Order Act says if there's a demonstration and there is some unlawful conduct, it is the leaders that you pick up.
Sure.
So, in fact, some people have been picked up. There's the youth chief for the area who was a key organizer together with the MP who presently, I think they've all been granted bail or so.
Yes. So, I mean, continuing, I think that the standoff, in my honest view, following him in church and wherever, it's a cowboy's fault. I mean, Ghanaians are not to be fed with these sins. And I think they can do it with much more... We do respect.
How?
No, like I said, they go to court.
Okay.
If you go to court, justify your action before the court, because the police are also making themselves.
You're saying go to court for an interpretation.
I haven't gone there. I haven't gone there. As for interpretation, there is no issue of interpretation.
Yesterday, Kwesi was telling me that they are likely to issue criminal summons.
Yes.
So they will go to the court, and then perhaps, if he still doesn't show up in court, the courts will issue a bench warrant for him.
That is so.
But if the court issues the bench warrant, it is still the police that will have to serve it on him, execute it.
Yes, and they will do it through the protocol. And if he is served, for instance, on a speaker and he doesn't, he's a fugitive of justice. Then next time, somebody will arrest him and bring him to the police.
But the speaker has declined one already.
Well, let the keep hold the cup, because that's how we build forces. So the speaker has to ask himself, how long can he continue on that path? Now, this is coming from the court. You are the lawmaker. Are you going to look the judges in the face and tell them they also do not matter? Then at that point, somebody will begin to sit up. Do
you have a feeling the police want to complete this thing because they have been summoned before the Privileges Committee, quote unquote, to be disciplined for breaching the protocol?
You know, talking about even that procedure that the speakers, you know, I was looking at it, you know, from elementary law that we did, that the police, they work under command, vicariously liable, I mean, through the IGP for their actions. So that if they really want to have a face-off, that policeman who was found at the site or the scene was there by command from the very top. And if the parliament really want to have a proper show of that summons or that whatever ought to be served on the IGP.
So they are doing something wrong.
That is so. I think they want to have it cheap.
I now get something. The ACP Kosifori told me yesterday on Newsfile that if it is properly served on them,
that is so.
They will take a decision what to do.
That is so. Because the proper thing to do is to serve the IGP. It's the IGP who must come and face you. These are his boys. They acted on the instructions. And it got no right whatsoever summoning his boys, knowing too well that as a matter of law, indeed the speaker is a lawyer and he knows better. So is a lawyer and he knows better. At the time that he made the complaint should have been against the IGP. And if these boys were cited, they were cited just because they were on site. And therefore, it's for the commander to come and justify the conduct. Because see, if you pick on the police, please, I want us to look at it from this way. The way we intimidate our police so that they're unable even to assert themselves. This is the way it is done. They are crippling the police. They are putting fear in the people who are down the line, whose only duty is to execute orders from above. So I believe that even that summons that have been issued by the MP is out of order.
The speaker?
Yes, the speaker is out of order, completely out of order.
Interesting. Mami, what do you say briefly about that? And then we may come to whether or not there are exceptions. And I'm asking about the exceptions because we have read about questions about, so if an MP commits murder, they are on the way to Parliament, so we should let them go. And then what? If they jump traffic, it's okay, let them go because they have immunity. We can go to the speaker and ask for them to be released before we investigate them.
Right. So I don't think I have any further comments. I think Lawyer Paintsil has said basically everything I would have said, so I wouldn't want to waste much time on that. But about the exceptions, there are two things I want to raise. The first is that when you look at the Parliamentary Act, Act 300, which I cited earlier, which sort of repeats what is in Article 117 in Section 20 of that Act. In Clause 2 in Subsection 2 of that Act, it said the Speaker, on an application being made in that behalf, may direct that Paragraph A of Subsection 1, which is on the arrest or the service of process, shall not apply to the service or execution of a criminal process specified in that direction. So if the police, for example, makes an application to the Speaker about a service or an arrest that they want to do, the Speaker can make that exception to it. And then secondly, I think that the parliamentary MP's immunity is not absolute but qualified.
I think they understand that it's not absolute.
Yes, and so of course there are exceptions, and that it doesn't mean that there will be a time when they will not be engaged in parliamentary duty. And so if they should be committing murder, then for example, if in an absurd situation where an MP is committing murder and because of this privilege, a police refrains from arresting, there's room for that arrest to be made again. But then also in where I just want to do a little history of how these parliamentary immunities came about, and from where they came from, that is in the UK, it didn't include, the immunity wasn't, criminal processes weren't included. It was only for civil arrest or civil summons and civil issues and civil processes. And so we could also, in reviewing, for example, or relooking at this law, consider the fact that criminal processes could be taken out of it so that that immunity applies only to civil cases.
But wouldn't that be dangerous? I'm an opposition politician. The government in power has some sinister stuff about me. They want to cripple me. There is some voting that has to go on in Parliament. Where we have a Parliament that is divided in the middle, we will try arrest one or two so that our side will have the majority. Don't you imagine some of these things happening if this immunity is not included, does not extend to arrest?
I can see how that will be possible, but I think that in the long term, when there's a sitting to consider it properly, I think some of these caveats can be provided for. So maybe it would be certain criminal processes, or it could be that there's an emergency plan so that even when such an arrest is effected, maybe they can vote by proxy or something of the sort.
Okay, interesting. And some members of parliament are watching us and giving ideas. One member of parliament Good afternoon, Mahama. He says that parliamentary work knows no Sunday or Saturday. Indeed, committee works and speakers' assignments are carried out during the weekends. That is to say that if you suggest that the police should arrest an MP during Saturday or Sunday when they are about some other business, that they cannot, for now, interpret that to include proceedings or business of the House. Another MP, and good afternoon, Dr. Hamid, he says proceedings or business, that's for the two things. And he says, I think proceeding must be defined just as the court defined, quote, deemed to, unquote, in the case of Tofor versus Attorney General. And this MP is a student of the law. Yes, I don't know. You agree with Mami Efua that there's a need to clarify further in the long term, like it happens in Australia, she mentioned, so that we know perhaps what is Parliament's business, what is proceedings, and then what time the exclusion extends.
Well, it's very possible we may get to that time. Indeed, and in fact, you appreciate that Ghana's got a long constitutional history. I mean, beginning from 1916, 1925, 1946, 1951, 54, 57, 60, 69, 72, 79, and so forth and so on. And you notice that the constitutions get bigger and bigger and bigger up to 1992, because especially between the 1960 Republican Constitution and the 69 Constitution, realized that there was no a Bill of Human Rights in the 60 Constitution, who made these extensive provisions. But ordinarily, once we've got the laws there, the others are the allies or whatever that's supposed to issue to clarify provisions and portions of the enabling statutes. So I can expect that possibly the first time these things are playing themselves out in the public, issues are beginning to arise. Whether attending a wedding ceremony by a parliamentarian constitutes parliamentary duty, whether organizing demonstration for your constituents constitutes a duty. And as she has said, whether it will be 5 days from the time or 20 days from the time, or don't forget that we are in Ghana, and that what it means that we can define something that is Ghanaian.
Right. Let me say we almost forgot to open the phone lines. Let's open for our audiences to join us for some 5 minutes of your questions or comments. And I wanted to draw your attention. In 2018, a similar issue came up, and I had to write an article. I consulted the 23rd edition of what I say is arguably the world's biggest reference for parliamentary history and practice. That is Eskime Parliamentary Practice. And in there, I picked up this quotation. It said, in all cases in which members of either house are arrested on criminal charges, the house must be informed of the cause for which they are detained from their service in Parliament. It has been usual to communicate the cause of committal of a member after his arrest. Such communications are also made whenever members are in custody to be tried or have been committed to prison for any criminal offense by a court or magistrate, unquote. So this clearly gave me the impression that there are situations they can arrest and then inform the House later. They can detain and then inform the House later because they can make a communication. When will you say there is an exception to going to, attending at, or returning from the proceedings or business of Parliament?
I think this exception is only being brought up in this our country, because everywhere, from the US to the UK, when there's criminal matter, the police go ahead and do the arrest. It's only in Ghana here. You never heard of a parliamentarian or a senator who is shouting, doing a shout out with the police. I mean, come on, are we saying that here we've got more parliamentary or legislative duties than elsewhere? Everywhere, that's what they do. But they get them and arrest them, and what you read is about informing the House. What is unacceptable is after you've effected arrest and it's like the person being kept incommunicado or that Parliament is unaware. That is what they consider to be sacrilegious. But there has never been an issue. Indeed, and in fact, apart from what is rolling out in Ghana, I do not know of anywhere else where the arrest of a parliamentarian or the proceedings or the process of arresting a parliamentarian became an issue and people began to split swords and stuff like that. So it is only in Ghana. I mean, I don't know where else. I mean, come on, we read what they said, what the BBC, we watch parliamentarians who are arrested, all legislators, the police arrest them. Except that in those jurisdictions, more often than not, they go with a warrant. More often than not. So maybe our police may pick possibly something from those places. But in the case where the action was going on live and call it, but nonetheless, they must still have judges who must, because, please, as we closing this thing, let's bring it to the judiciary. Because, see, we know that in other jurisdictions, you can literally wake up a judge.
Let's talk to one of the constituents of the MP. Godwin from Oyarifa, I think that may qualify. And remember that we are looking at this issue broadly as a policy issue. Yes, let's hear from you, Godwin.
Yeah, please, I'm just watching your program, and I have so much interest in this program. My problem is about this parliamentarian saying that they have a parliamentary duty. You be an MP, we all know that, going to organize a demonstration on a public road that everyone uses it, it's not only your constituent that uses that stretch. Yes, the road is no good, but what is the essence of burning ties and all those things? So telling your constituents or be dancing your constituents burning ties, is it a parliamentary duty? That is my constituency, but I was not happy.
Okay, so as far as you are concerned, that is not part of parliamentary duty. Thank you. Emmanuel Martin from Kwehu. Let's hear you quickly, Emmanuel.
All right. Good afternoon to your viewers, and I'm really enjoying the show. But my question is, are we allowing honorable MPs who are lawmakers in the country to take the laws into their hands for the fact that they are MPs?
They are not simple MPs. Emmanuel, they are not simple MPs. They represent constituencies.
Yeah.
Yes.
I think for the fact that they are representing a whole constituency and a number of people does not mean the laws cannot work with them. I think we should be very much analytical on such issues and know that the fact that you are an MP representing a constituency does not mean you can do things just like that. And
Thank you very much, Emmanuel Martin from Kwehu. Let's go to Prince. Prince, you are calling from Akimoda. Let's hear you.
Yeah, I think we are having a crisis of hypocrisy, law enforcement. Why do I say that? Once upon a time, we have heard that the law enforcement led by Dampari is enforcing the law and have caused the arrest of two pastors, prophets, and then two musicians. Now, a member of parliament have committed an offense. Now, the parliament is defending that MP who have caused an offense. So, who is the law favoring now? And who is the law against now?
All right.
And who is trying to enforce what law?
Okay. Thank you. We cannot say that Parliament is defending them. The Speaker has referred the matter to the Privileges Committee for them to look at. Let's see how that pans out. Tony Ado, you are calling from Ashaman. I'm sorry, but you are the last we can take. Let's hear you.
Thank you very much. Good afternoon, Samson. And I believe it wasn't the MP alone that took part in the demonstration. Why is it that he must be arrested?
By the Public Order Act, it is the organizers of demonstrations that are responsible for breaches of the law.
Which the MP is part?
He's a key organizer of the demonstration.
Thank you very much.
You're welcome, sir. I'm sorry, but that's all time will allow us. Very interesting. But please, let's recognize that the MPs are not, you can't say they are mere, they are in a privileged position. They represent a whole constituency. So let's understand that. Now, let me take your very final comments as to going forward with this. Let's hear Mami Efua. Hello, Mami Efua.
Yes, so my final comment is that much as we are trying to deal with this instance issue, we should look in the long term and try and settle this issue once and for all. Because like you said, the Speaker is saying that he has had a number of similar cases. It seems to be this seems to be the one that has blown up. Yeah. And so to prevent future situations like this, we should settle it. And I would prefer that it should be settled through the law rather than the courts, because in an attempt to interpret this provision, the courts might end up legislating and usurping
but if it's going to be settled through the law, it is the MPs that will change the law.
Exactly, I get it, but then we can try both. We can try the court, and then maybe the court would, based on what the court would say, they would take it up from there,
right,
and look at that. And I think for the criminal provisions, like Paintsil said, in the US, for example, where they exclude criminal provisions, it states in their constitution explicitly in Article 1 that it excludes treason, breach of peace, and a felony. So if the criminal offense covers these things, they can arrest you.
Oh, I see. That's interesting. If it is treason, felony, and she mentioned one, then the privilege doesn't apply. Interesting. Mame Ifwa Adadzi Kom is a lecturer, Faculty of Law, KNUST. Now, Senior, what will be your final words?
Yeah, I was going to put the point that our judges must now be closely involved. My advice to the police is that maybe limiting themselves to the parliamentarians alone. Elsewhere, everywhere, judges can literally be woken up from sleep to issue orders and warrants and stuff. So I'm thinking that in the peculiar case of our MPs, the police should be looking more at that. And when a judge has issued a warrant, it's not for the Speaker of Parliament, it's not for the particular parliamentarian. He has to come to court and assert that right or privilege for a judge to determine whether he's entitled to it. Okay. That would be my final comment.
Thank you so very much. Kweku Paintsil is head of Paintsil and Co. And as you heard from them, this matter has come up over and again too often, including MPs facing criminal processes in court and attending court. And the judges recently, Efia Asare Boche had to, be stern on it in the Mahama Yarga case. So the way forward is to look at the long term. This has been the law. It's your legal light. It's your help law. I'm Samson Ladi Anyanini. Join us again next week for another edition. Good afternoon.